Good afternoon, everyone. My name is Brett Swearingen, and I am an attorney at Miller Johnson in their Grand Rapids office. And I'm grateful you are sharing your lunch with me today while I get to discuss a topic near and dear to my heart, which is ESG and ERISA. This is one of our monthly benefits webinars. We are doing these every month on the third Wednesday of the month. So the next one will be coming up in May, but we have one scheduled through the end of the year. Feel free to register at the link below. So let's get started. I named this presentation ESG and ERISA, Holy or Unholy Alliance, the latest from the Department of Labor, trying to be a bit dramatic, but I think as you'll see, there is a little bit of awkwardness in the fit between the two, but hopefully we can straighten things out by the end of the presentation. Just the typical caveat that this is not legal advice, but we are happy to provide you legal advice if you want to give us a call later. Okay, here's what's on tap for today. I want to go through the background to this topic. There's a lot out there, but I'm going to try to be pretty brief, both the legal background, ERISA and what it says, and what ESG is, where it's come from. I want to talk about the first rule to address these topics, which came out in November 2020 in the Trump administration. Then what the Biden administration has proposed in their proposed rule that came out October of last year. I'll give a little bit of crystal balling on what I think will be in the final rule, which we haven't seen yet, and then finally conclude with some takeaways and hopefully have some time to respond to questions. Okay. I wanted to give you just a little background about me. I'm relatively new at Miller Johnson. I started last March. Before that, through January of last year, I was in the Labor Department, part of the Trump administration, and I was involved very heavily in the drafting of their ESG rule. So I'm speaking of what I know, at least in terms of the 2020 rule. I will try to be as objective as I can, but that is where I come from. Before that, I did a lot of ERISA work at a big firm in Washington, D.C. Now I'm doing both ERISA and labor and employment here at Miller Johnson as of last March. Okay, some caveats. ESG is a very, very big topic. It has a lot to do with investing of all sorts. This presentation only is about ESG in the retirement plan context, where ESG interfaces with the statute ERISA, which governs American retirement plans. We're not going to be talking about the merits of ESG as a general investment strategy, what people want to do with their money on the side, or what people think of it as a environmental activism strategy for that matter. In particular, we're not going to be discussing other government rulemakings in the ESG space. Most notably would be the SEC's one that I think was released in March, a proposed rule that would talk about what kind of climate disclosures are required for public companies. So we're just talking about ERISA retirement plans and what the Department of Labor, which regulates ERISA, has said that is relevant to ESG. Please do ask questions. I will be doing my best. Even to, if there's questions during the presentation, maybe I can clarify something. Otherwise, I will be trying to answer whatever comes in the time left at the end of our presentation. So what is ESG? ESG stands for Environmental, Social, and Governance Investing. It's a term that's become in vogue in the last few years. I don't know precisely when it was coined, but basically it's an umbrella term for an investment strategy that does emphasize looking at the environmental or social practices of a company or the company's governance in how the investor makes decisions with his or her money. It comes out of a fairly long tradition, going back to at least, I would say, the 70s, where you may remember the term SRI, which stood for socially responsible investing. This was a big deal in the context of South African divestment. Other terms you may have heard over the years are ethical investing, economically targeted investing, sustainable investing, responsible investing, and impact investing. As you'll see as we move through the slides, ESG and ERISA gets tricky due to the fact that the ESG movement, ESG investing, is used broadly, and in some contexts, when people talk about ESG, they're talking about purely financial goals. There are investors who think if you invest with E, S, and G factors in mind, you can actually make more money. There are other people who use the term ESG who, while still trying to make money, are willing to concede some loss of investment return or take on more investment risk because they're more focused on certain environmental, social, or governance goals over strictly making returns on investment. And as we'll see, ERISA allows for one and does not allow for the other. So ESG is just a tricky concept when put into the ERISA framework. What is ERISA? I apologize for not defining this at first. I don't want to presume anybody here is a lawyer or just knows statutes, but ERISA stands for the Employee Retirement Income Security Act. It is a federal law passed in 1974 that protects, regulates Americans' retirement savings. For most people, that means the pension plans that Americans have in the private sector, not public sector, as well as 401ks that employees have via their employer. Most importantly, for this discussion, ERISA sets very high standards for fiduciaries. Fiduciaries are the people who are in charge of managing retirement plans. And some courts have even said that the fiduciary standards set by ERISA, which have their own long pedigree that go much beyond 1974, are, quote, the highest standards known to law. Two of these standards are particularly relevant when we talk about investing retirement savings in ERISA plans, and those standards are the duty of loyalty and the duty of prudence. I'm going to quote from the actual statute here. ERISA defines the duty of loyalty as requiring fiduciaries to act, quote, solely in the interest of the participants and beneficiaries of the plan, and for the exclusive purpose of providing benefits to participants and their beneficiaries. The Supreme Court shed a little bit of light on this section of ERISA in a 2014 decision where they unanimously decided that the term benefits, in what I just quoted above, refers to financial benefits, such as retirement income. That's a quote from the opinion, rather than non-pecuniary benefits. Pecuniary is an old word that means financial. You'll be hearing a lot of it in the next few slides. So the duty of loyalty basically means if you're a fiduciary of a retirement plan, if you're investing other people's money, your concern has to be exclusively for their benefit. You are trying to make sure they have money to retire and that money is secure. You cannot act for the benefit of yourself, for the benefit of your employer, for the benefit of anybody else, for a political purpose. Your exclusive purpose when acting as a fiduciary is to be providing benefits to participants and their beneficiaries. And those benefits, as the Supreme Court said in 2014, are financial benefits, like retirement income. Courts have interpreted this duty of loyalty as requiring fiduciaries to act with, quote, complete and undivided loyalty to plan beneficiaries. And in another famous decision, that the decisions be made with, quote, an eye single to the interests of the participants and beneficiaries. Now, I think it's clear when you read these descriptions of the duty of loyalty, whether from the statute or from court decisions interpreting the statute, that what Congress was really trying to do was regulate the motive of fiduciaries. When you are a fiduciary and you're making decisions on others' behalf, you should be motivated by their good, not your good, not the company's good. And I think that's completely right. The problem is regulators, lawyers, judges don't really like motive tests because motives are subjective, motives are internal. There's no way for a enforcement officer at the Department of Labor to look inside someone's soul and say, oh, it's clear they're actually trying to help, their cousin, and not try to help participants. So motive tests are not favored in terms of regulation and enforcement, even though I think it's clear that the proper understanding of the duty of loyalty is it is setting up a motive test, that fiduciaries' motives must be solely for the interests of the participants and the beneficiaries of a benefit plan. That's just a complication that we have to deal with when we're dealing with ERISA, and especially the duty of loyalty. The other duty I mentioned is the duty of prudence. This is basically the duty to act competently, professionally, make reasonable decisions, weigh options intelligently. Quoting from the statute, the duty of prudence requires fiduciaries to act, quote, with the care, skill, prudence, and diligence under the circumstances then prevailing, that a prudent man acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims. This is also sometimes described as the duty of care. I think this makes obvious sense. You don't want somebody who is investing millions, even perhaps billions of dollars, to be reckless or careless. They should be making good decisions based on good information, based on proper diligence and proper consultation. So that is the duty of prudence. How does this relate to ESG? Well, as I'll get to soon, ESG poses perhaps some temptations for fiduciaries to stray from the duties of loyalty and the duties of prudence, depending on the situation, depending on what kind of ESG we're talking about. As I said, it's a slippery concept. So the Department of Labor, as I referenced earlier, is the federal agency that is responsible for regulating private retirement plans that are covered by ERISA. As I told you, ERISA was passed in 1974. Almost from the beginning of ERISA, there has been pressure put on the agency from various groups for various causes to sanction the use of workers' retirement savings for various purposes. I mentioned a few slides ago that there's pressure to divest from South Africa. So I think early in the 80s there were people asking the department, is it okay to use our plans, retirement assets, to divest from South Africa? A common request has been from pension plans operated by unions, if they could target their investments only on construction projects that use union labor, especially if this is a pension plan for, construction laborers. It makes lots of sense. A way that they could both ideally build retirement savings, but also create more jobs for union members. So even from the very beginning, this has been a question that the Department of Labor has had to address in the ERISA space, and in particular, how this interfaces with the duties of loyalty and the duties of prudence. But as far back as 1980, the leader at the time of the benefits office within DOL wrote in a speech that was later turned into an article, economic considerations, quote, economic considerations are the only ones which can be taken into account in determining which investments are consistent with ERISA standards. And the leader of the benefits office warned that fiduciaries who exclude investments for non-economic reasons would be, quote, acting at their peril, end quote. Now, the department engaged these issues a little bit more substantively beginning in the 90s. It issued its first bit of sub-regulatory guidance. So not a regulation, but a document that the agency puts out giving guidance to fiduciaries, though it doesn't have the force of law. If you follow this issue, and I don't want to presume you have, since the 1994 guidance, there's basically been a regulatory ping pong as administrations have come and gone. There has been successive guidance in 2008, then in 2015, each kind of going back and forth from the prior guidance, and then there's the Trump rule that came out in the fall of 2020. The 1994 guidance formalize something that had been said before, but in less formal context, that's become to be known as the tiebreaker rule. The tiebreaker rule in the 1994 guidance said that when a fiduciary is looking at competing investments and the fiduciary determines that either investment would serve the plan's economic interests equally well, the fiduciaries can then, in effect, break the tie by using non-financial considerations. So to use that South African divestment example, let's say a fiduciary was looking at a fund to possibly add to their 401k menu, and there was a fund that did not have any South African investments and another fund that did have some South African investments, but when they looked at all the financial metrics and expected returns, they were the same. In that case, they could say this is a tie, and I'm going to choose the fund that does not have any South African investments using the quote tiebreaker rule, also known as the all things being equal test. As I said, there's also been guidance since the 94 release in 08, in 2015. This is the ping pong, subtle changes in emphasis each time. Though there has been a lot of consistency, which I want to stress again and again, because despite this kind of back and forth, the emphasis change, each time the department opened its mouth on these issues, it would consistently say that fiduciaries violate ERISA if they accept reduced expected returns or accept greater risks in order to secure social, environmental, policy, or other non-financial goals. So that has been a bedrock. The question has been at the margins, to what extent can you consider things that do not appear to be financially related to the interests of the plan? Okay, so the Trump administration did, for the first time, a rule on this topic. Rather than doing another guidance ping pong in the fall of 2020, they released an actual regulation addressing ESG and how that relates to ERISA, in particular the duties of loyalty and prudence. Let me give you a quick overview of the highlights of that rule. I apologize here, but the rule used the term pecuniary to kind of structure the fiduciary's role under the duties of loyalty and prudence. And they did that because, if you remember, that was a word used by the Supreme Court in that 2014 decision in defining what the term benefit under ERISA means. So instead of using the word ESG, which DOL decided is not a clear standard for regulation, given that it's slippery and imprecise and can mean different things, and even taking for what it is, it's an aggregation of 3 categories of terms and depends on what is the particular investment in question. Rather than using the term ESG, they use the term pecuniary, which is basically a synonym for financial. In the rule, the pecuniary factor is defined as a factor that a fiduciary prudently determines is expected to have a material effect on the risk and or return of an investment. And again, this is going to drive much of what the 2020 rule says. In general, according to the 2020 rule, plan fiduciaries, when they evaluate investments, their evaluation, quote, must be based only on pecuniary factors. In addition, repeating this language you've heard before from the earlier sub-regulatory guidance, fiduciaries, quote, may not subordinate the interests of the participants and beneficiaries in their retirement income or financial benefits under the plan to other objectives, and may not sacrifice investment return or take on additional investment risk to promote non-pecuniary benefits or goals. So this is simply meant to say, when you're looking at investments, when you're deciding what the plan should do, if it's a pension plan, how to spend your money, if it's a 401k, what options should be put on the menu for employees to select from, you should be guided only on pecuniary financial factors that you think is in the best interest of the plan, the participants, and the beneficiaries. Basically, this is kind of a way of interpreting the duty of loyalty, along with the Supreme Court's clarification that benefits refers to financial benefits. The Trump administration's rule also narrowed the tiebreaker rule. The rule said that fiduciaries can only break the tie with a non-pecuniary factor, a non-financial factor, if they are, quote, unable to distinguish between different investment options on the basis of pecuniary factors alone. So if a fiduciary is looking at two or more investments, only looking at the financial factors relate to those investments, expected risk and return, and cannot, by those financial factors, say that one would be better for the plan than the other, they are permitted under the rule, under ERISA, to make a selection on the basis of a non-financial factor, whether that's an ESG factor or any other factor. The other big thing that the 2020 rule did is prohibit investment funds as default plan investments. Default plan investments are investments that a plan participant is auto-enrolled in if he or she does not make an affirmative election. So if you don't, when you sign up or start a job with a new company and you've just never signed up for their 401k, the plan will automatically enroll you in the default investment. In ERISA speak, these are called QDIAs, stands for Qualified Default Investment Alternatives. Anyway, that's just background to say that the 2020 rule says you cannot be enrolled in a default investment if that investment has investment objectives or goals or principal investment strategies that include or use non-pecuniary factors. In shorthand, this basically means, it requires a little more diligence by a fiduciary. You can't have an ESG fund as a default plan investment. The idea there was if a participant wants to invest in an ESG fund, he or she should do that on an affirmative basis, but it should not be something that they are just defaulted into. Okay, so that was the 2020 rule. Some summary points, just to clarify. The Trump rule did not ban ESG investments in retirement plans, nor did it prohibit the consideration of ESG factors. Again, this is complicated because ESG is a slippery concept. Certainly, lots of ESG factors may be financially material to an investment. An easy example would be a company emits a lot of carbon, and there either is a law on the books, or very likely there will be a law on the books that penalizes companies that emit carbon. Clearly, the fact that that company is emitting a lot of carbon, although it's an environmental factor, that is definitely a pecuniary financial factor. But there are other cases where an environmental factor is not relevant to the financial success or non-success of a company. Or more complicated, could be a factor is financial material for one company, but not for another company. So in effect, the point is that for a fiduciary, whether a factor or a fund or an investment is ESG is not the right question to be asking under ERISA. The right question to be asking, and I'll quote from this, the bottom of the slide here. This is a quote from the 2020 rule. From a fiduciary perspective, the relevant question is not whether a factor under consideration is ESG, but whether it is a pecuniary factor relevant to an evaluation of the investment under consideration. So ESG factors, they may be pecuniary, may be non-pecuniary, they may be pecuniary in one context, but non-pecuniary in another context. There's no ban on considering them or requirement to consider them. The question is the factor pecuniary? And it could be an ESG factor, it may not be, but we need to focus our attention on whether it's a financial factor and not whether it's an ESG factor. Okay, let's move on to the Biden administration. So shortly after President Biden took office, the Department of Labor announced that they would not be enforcing the 2020 Trump ESG rule, as they were going to be working on a replacement. And sure enough, in October of last year, the department released a proposed rule that would replace the 2020 rule. They've received a lot of comments, and I'm sure busy reviewing and revising that proposal, but as of today, there has not been a final rule released. So this will only be discussion of what they proposed. I'll give you my best prognostication on the final rule, but we don't have it yet. So similarities with the 2020 rule and everything the department has said before. You'll hear me say this again. The proposed rule affirms that ERISA requires fiduciaries to focus on material risk-return factors and not subordinate the interests of participants and beneficiaries to objectives unrelated to the provision of benefits under the plan. So that's all consistent with what the Department of Labor has said in the 2020 rule and going long before that. Here's the change. The proposal, if it makes it into a final rule, would add language stating that fiduciaries' consideration of investments, quote, may often require an evaluation of the economic effects of climate change and other ESG factors on the particular investment. That would be the big change. There's, as I said, there's no discussion of ESG or any type of factor in the 2020 rule, except from the fact that you only can consider pecuniary factors unless you're in a tiebreaker context. So that's the biggest change that the Biden administration proposed. Related to that, in the proposal, the Department of Labor listed several examples that could, depending on the facts and circumstances, may be material to a fiduciary's risk-return analysis. So in the language of the 2020 rule, they listed some ESG factors that could, again, depending on the circumstances, be a pecuniary factor. So under climate change, they listed a corporation's exposure to the real and potential economic effects of climate change, including exposure to the physical and transitional risks of climate change and the positive or negative effect of government regulations and policies to mitigate climate change. I should have mentioned, an environmental factor could be bad for a company that emits carbon, but it could be good for a company that makes electric car batteries. So environmental factors can go both ways. Under governance factors, the department listed factors involving board composition, executive compensation, transparency and accountability in corporate decision making. And then under workplace practices, which I think would fall under the social, the S in ESG, they listed corporations' progress on workforce diversity, inclusion, other drivers of employee hiring, promotion, and retention, a workforce's investments in training, equal employment opportunity, and labor relations. So the proposed rule that the Biden administration puts out is suggesting these kinds of factors are things that a fiduciary should look at least to determine if they are, in fact, material to the risk-return analysis, in which case they should be considered as fiduciaries make investment decisions. And again, this list were not included in the 2020 rule. In terms of the tiebreaker rule and default investments, the proposal would reduce the restrictions put on the tiebreaker rule by the 2020 rule. The language of the proposal says that non-financial factors can break ties whenever fiduciaries determine that competing investments, quote, equally serve the financial interests of the plan. However, the proposed rule would require that if, excuse me, if the fiduciaries were using the tiebreaker rule to select a fund to put on a investment menu, say a 401k menu, that the fiduciaries must make sure that the non-financial characteristic of the fund is prominently displayed in the disclosure materials. I think this is just to make sure that a plan participant would know if they're selecting this kind of a fund, that this kind of fund, they have a focus on climate change or what have you, that kind of transparency. In terms of default investments, the Biden proposal would just eliminate the restriction that the 2020 rule had, so there'd be no obstacle except for the regular duties of loyalty and prudence to having a default investment that has an investment strategy or goal or objective that is non-pecuniary. So what is going to happen? This is just me speculating. I know that's always dangerous. I would not expect the final rule will be very dissimilar from the proposed rule, but I do think it's possible, maybe likely, that that language I highlighted before about may often require evaluation of climate change and ESG factors. I think that, if anything, that may be softened or eliminated. I know that's gotten a lot of pushback. Also has people who support it, but in ERISA world, so to speak, it just sticks out because typically the Department of Labor does not give any substantive specificity as to what fiduciaries should look at or what they should not look at. It's very much historically been, you're a fiduciary, that's a big obligation. You have to be loyal, you have to be prudent, but we're not going to tell you what it means to be loyal and prudent. You use your own professional judgment to determine what is in the best interest of the plan. And some people who oppose this kind of language may often require as an attempt by the regulators, the department, to put a thumb on the scale and basically tell fiduciaries that you probably should look at climate change, and maybe if you don't, you might get some attention from our enforcement officers. So I definitely could see that being removed or softened, but I could see it staying in. Generally, I don't expect that the final rule will be too different from what the proposed was. Again, I realize it's dangerous to speculate. Okay, so given what's been going on in this space, and frankly, there's been a lot of attention to ESG in the regulatory space in just the past few years, and I think that's consistent with how much attention ESG investing has gotten. It's really been rising substantially if you look at the number of funds being offered, the amount of cash flows going into ESG type funds. There's just a lot of things happening, even more so in Europe. What should we do with all these changes? I think the first thing is to remember, I've tried to emphasize this point, despite the regulatory ping pong, which we'll probably have another edition of whenever this rule is finalized, the underlying law still has not changed. The statute has not been changed. The duties of prudence, the duties of loyalty, that hasn't changed. The Supreme Court decision from 2014 that says that when the statute talks about benefits, that the statute means financial benefits, that hasn't changed. And even the core theme in the Department of Labor's guidance going back to '94 and even beyond, and in the Trump rule and in the Biden proposed rule, that you can't subordinate investment return for some other factor to benefit something else. You can't take on additional risk for some other purpose. That hasn't changed. So the basic fundamentals of how a fiduciary should carry out his or her duties have not changed. So that is just an important thing to keep in mind. There's a lot of things to distract you from that, but that is still true. Second, I raised this on the front end. You need to be able to distinguish good from bad ESG, and I have those terms in scare quotes because this is good and bad from an ERISA perspective. It's not necessarily good and bad from a policy or ethical perspective. There's nothing inherently wrong with wanting to do ESG because you want to try to change market actors' behavior. You want to, make less carbon emissions or make agricultural companies treat animals differently. There's nothing wrong with that. It's good and bad from an ERISA perspective because ERISA does say, as I started the presentation with, you have a duty of loyalty. You are only allowed to look for the interests of your plan participants and beneficiaries. So you should be wary of an investment that is claiming to do other things and is not primarily focused on having stable and secure investment returns that you can use for your plan participants. On the other hand, as I said at the front, some ESG is entirely financial. They are putting forth an investment strategy that says, if I look at these types of factors, if I choose investments based on ESG factors, I can actually make more money. I will do better from a strictly financial perspective than if I don't. So that would be, clearly there'd be nothing wrong with that kind of ESG and ERISA. There'd be no conflict at all. Bad ESG, dangerous, and certainly dangerous, or not just dangerous, but illegal, is if a fiduciary, him or herself, had those motivations and said, I know I'm a fiduciary, but actually I think it's more important that our plan's assets are used in a way that benefit the environment or help increase diversity of workplaces or diversity of board compositions. That would be an improper motive for a fiduciary under the duty of loyalty. Okay, number 3, a very common bit of advice in the ERISA space is document your decisions. So whenever you're making investment decisions as an ERISA fiduciary, document the decision, and in particular, document why the financial factors lead you to that decision. What are the financial factors that make you choose this investment over another? And this is true whether or not we're talking about an ESG investment or your average investment. But certainly in the ESG context, if there was concern that you were improperly trying to benefit an ESG interest rather than your plan, you want to have documentation shows, no, this is why we chose this investment. These are the reasons. These reasons are about the financial interests of the plan. Again, whether or not there's an overlay between ESG factors. So everything I've said is very, very high level. I hopefully gave you a good summary of what the Department of Labor has said recently and will say soon, but I know these questions can be very specific, and that is something I'm not able to help with at this level. But so if anything specific arises, please reach out to your benefits attorney, whether that's me or one of the other people on the benefits team here at Miller Johnson. And with that, if anybody has questions, I am happy to answer them. I have quite a bit of time, so maybe I went too fast. I did get one question submitted in advance. Let me look at that. The question was, would it be appropriate for a retirement plan committee using a 338 advisor, that's a statutory reference to an investment advisor, raise this topic in discussion or have an opinion on this, or have we effectively signed off on that responsibility and therefore it is too meddly? So my first response would be, I'd want to know what kind of agreement you have with the 338 advisor. It's possible the agreement you have with that advisor kind of limits your role, but as a general matter, you are still a fiduciary even if you have a 338 advisor. Your fiduciary duties are more limited. You're monitoring the advisor and being responsible for making a good selection of an advisor and monitoring the ongoing performance. But you're still a fiduciary, and if you have an opinion on this as a general matter, I don't know why you couldn't bring it up, ask questions. I don't want to say too much because I don't know what kind of agreement you already have with the advisor that might put other barriers to that kind of a discussion. Okay, guys, thanks again for letting me talk about this topic, which I am very interested in with my experience. It's been great. And if you have any questions, please drop me a line, send me an email, and I would love to help. And if I can't help, I would certainly pass you along to one of my colleagues that could help. So have a great afternoon and take care. Bye-bye.